As you've been learning from these materials, the workplace civil rights laws prevent discrimination, harassment, and retaliation in the workplace. While these principles have a broad scope, they don't prohibit every kind of offensive workplace behavior. That is, there's some offensive conduct that's beyond the scope of the employment laws that managers could do to employees, or employees could do to employees, or employees could do to managers. We've even seen that happen. But this type of conduct, which often involves what you'd call bullying in the workplace, can still become fodder for lawsuits alleging claims of discrimination, harassment, and retaliation. How can that be if bullying falls outside the workplace civil rights laws? It's because often those are the only legal claims available for an angry employee who has been terminated or harassed by a bully and wants to get back at that manager or get back at the company. So these claims get brought even though they may not be the most meritorious claims, and the lawyers who bring them push the legal envelope in the hopes of a favorable settlement. And thus, a manager who bullies his or her employees can wind up as the target of a lawsuit, even though there's been no discrimination, harassment, or retaliation in the classic legal sense of those terms. These cases can be very tough to defend. If the evidence is clear that a manager really was bullying his or her employees, the company may be forced to assert what some employment lawyers refer to as the equal opportunity harasser defense. The theory is that the manager may have treated the plaintiff badly, but he or she also treated other employees badly too, and didn't discriminate against women or men or African Americans or Caucasians. As you might imagine, that defense often doesn't play well to a jury, since the jurors in most of these cases work for a living, and they take the evidence that's been presented and view it through the prism of their own experiences. Of course, most of these working people would not enjoy having a mean boss, and here they are, sitting in judgment of whether the plaintiff's boss should be held accountable for his or her behavior. So you can see how bullying and other types of workplace behavior that are on the fringe or just outside the coverage of the civil rights laws can still lead to big problems and potentially costly litigation.